Hey everyone, and welcome to this explainer. Today, we're stepping right into what feels like a cinematic legal mystery. Imagine you're just going about your daily life, making dozens of little agreements. Promises to meet up, promises to pay for a coffee, promises to help a friend move. But what actually happens when one of those everyday promises gets broken? Can a simple, harmless broken promise really land you in a courtroom? Well, today we're going to explore the invisible boundary that separates a simple, everyday promise from a rock-solid, legally binding contract. Picture this for a second. You're sitting at your favorite restaurant, stomach grumbling. Your friends swore they'd buy you lunch today. But then, right at the last minute, your phone buzzes. They text you saying they can't make it. You're hungry, you're annoyed, and honestly, you've just wasted your time. So, can you sue them for the cost of that lunch? I mean, it sounds totally ridiculous, right? But to a law student, it actually poses a very real, very foundational question about how our whole society operates. Why do courts care so deeply about some promises but literally ignore others? Okay, let's dive right into this. The answer all comes down to one core concept: intention to create legal relation. Think of this as an invisible shield. It's the ultimate deciding factor for whether a judge will actually step in and enforce an agreement. Without this intention, you basically just have empty words floating in the air. But with it, you have the full, heavy power of the law backing you up. And to figure out if this invisible shield exists, the law basically splits our lives into two very distinct worlds. Let's take a look. First up, we have World 1, the home. This is the realm of domestic and family agreements. In this cozy, everyday realm, the law makes a very specific assumption, which we call a presumption. Whether it's a casual agreement between a husband and wife, a parent and a child, or just a general social arrangement between buddies, the law stamps a giant red label right on it. And that label says, usually no intention. The courts assume that when you promise your mom you'll clean your room, or you promise your best friend you'll buy them a pizza, you are absolutely not intending to create a legal relationship. These promises run on love, trust, and friendship, not the threat of a massive lawsuit. So how does this actually play out in real life? Well, take the famous case of Balfour v. Balfour. A husband promised to pay his wife a monthly allowance while they lived apart. When he stopped paying, she sued, but the court said, no way, that was just a domestic promise, not a formal contract. We see the exact same logic with parent-child promises in Jones v. Padavatten and social agreements in Chu Tiong-hin v. Cho Hak-sui. These historic cases absolutely prove that family arrangements are meant to stay far, far away from the courtroom. But wait, here is our first plot twist. When home gets legal. What happens when that cozy domestic world breaks down? Well, the no-intention presumption from Balfour isn't set in stone. It can actually be flipped. If a couple is separating and they start putting asset divisions down in writing, like we see in the cases of Merritt v. Merritt and Pettit v. Pettit, that giant red label gets ripped right off. Because they are legally separating, the court steps in and says, yep, in this specific serious situation, you do have intention. All right, let's step out of the house and into World 2, the business. This brings us to the commercial presumption. Now, over in the commercial world, the stakes are way higher. We're talking buyers, sellers, massive companies, fleets of delivery trucks, and seriously large sums of money. Because of all this, the law slaps a giant green label onto these agreements that says, usually have intention. Listen, when businesses shake hands on a deal, they aren't doing it out of love or friendship. They absolutely expect legal protection. If a supplier suddenly fails to deliver their goods, you better believe the buyer fully intends to have the right to drag them into court. And the courts fiercely protect this business environment. Think about the crazy, famous Carlisle v. Carbolic smokeball case. A company promised a cash reward to literally anyone who caught the flu after using their product. When a customer actually got sick, the company tried to back out, but the court held them to it. In cases like this, and in CSCO Hung v. Lim Sim Xian, the courts strictly expect that if you are engaging in commerce, legal intention is the default setting. It's just how the game is played. But hold on, we've got another plot twist. This one's all about the magic words. Behold, the magic words of the legal world, subject to contract. If a business decides to drop this specific, tiny clause into their agreements, it acts as a massive legal stop sign. It completely rebuts that green have intention presumption. It's basically a megaphone telling the court, hey, we're just negotiating here. We're making plans, but do not legally bind us until a formal, finalized contract is actually drawn up and signed. And we know for a fact these magic words work because of exception cases like Win v. Bull and Lokar Yit v. Mohad Isa. By simply writing the words subject to contract during their lease negotiations, these parties successfully stripped the agreement of its immediate legal power. It is, quite literally, the ultimate escape hatch in commercial law. All right, let's lock in this ultimate color-coded memory trick for your exams. Ready? Red house, home equals no intention. Green building, business equals have intention. This simple little contrast is the foundational framework you're going to need to analyze pretty much any problem they throw at you. So let's actually test this out with a quick interactive exam scenario. Imagine a husband and a wife sit down and make a casual agreement. Based on the two worlds we literally just explored, is there legal intention here? Take a couple of seconds to think about it. Got your answer? Okay, if you said no intention, you hit the nail right on the head. The presumption for the domestic world is always that there is no intention to create legal relations. But hey, pro tip, remember to always add the caveat on your exams, unless the plot twist exceptions apply, like if they were separating as we saw in Merit v. Merit. Awesome, let's try just one more. Exam scenario number 2. A commercial company makes a massive deal with a new supplier. Is there legal intention in this case? Lock in your answer right now. Got it? Spot on. The presumption here is that they have intention. Because they are operating out in the business world, the law assumes they absolutely want the protection of the courts. But again, don't forget your magic words. This presumption stands tall unless it is specifically rebutted by the escape hatch clause, subject to contract. To bring this whole shebang together, here is your absolute ultimate study guide for exam prep. Seriously, everything you need to understand this topic is mapped out beautifully right here. On one side, you've got the domestic world, starting with no intention, plus its exceptions. And on the flip side, the commercial world, starting with have intention, complete with its subject to contract escape hatch. Take a mental snapshot of this, and you'll have these two diverging paths locked in for good. So as we wrap up this explainer, I want you to take a second and think about your own daily life. The next time you tell a friend you'll cover their coffee, or the next time you send a quick business invoice at work, ask yourself, which world are you actually standing in? Are you in the cozy, safe realm of trust, or the strict, high-stakes realm of commerce? Because based on everything we've just uncovered today, the answer to that simple question literally changes everything. So, what do you think? Will your next promise hold up in court? Keep that in the back of your mind, and as always, happy studying.